Hi, it's Attorney Yoli Medina again. I have a video here where I'm going to talk about Mica's proposed law and how it compares to California's coercive control law. Because I practice in California, so I wanted to compare the two. One of the difficulties with the South Carolina proposed law is that it wants to criminalize the coercive control behaviors, which include isolating a victim from their family and friends, monitoring their comings and goings, stalking, financial abuse, and it covers things that are not necessarily physical abuse. And that's one of the things that I think might be hindering the passage of the law in South Carolina. I'm not sure, but that's what I think. Because criminalizing that kind of behavior, it would, well, first of all, it is difficult to prove. So one of the things that abuse victims have to learn is how to document and memorialize behaviors that are considered coercive control. In California, the coercive control law it's under the family code, and it's Family Code 6320, and it was put into effect in 2021, and so it's not a criminal. It doesn't criminalize the coercive control behaviors. What it does, it provides a basis for victims of coercive control behaviors from their significant other or domestic partner. And it allows a basis to bring a protective order or restraining order against the person who is committing the coercive control. And so it also provides a basis as in cases where there's a custody issue. Because if there is coercive control under the law in California, under the family code, there's a presumption that the victim who proves that there is coercive control going on is the better parent. And so there's a presumption that the custody of the children, if there are children in the relationship, there's a presumption that those children should go to the victim, not to the coercive controller. And so it provides a presumption, which means the burden of showing evidence that the abuser or the coercive controller is the better parent, it falls on him or her. Okay. Whoever is the coercive controller, the burden is on them to show they're a better parent. But first, the victim has to prove coercive control. Now, physical abuse is probably easier to prove, and I'm not an expert in family law, so I don't want to act like I am. But physical abuse is probably easier to prove, but coercive control is a little more subtle. And so there have been cases, and I'll post the link below. I'll post a link below of the article that I'm talking about, where several women, or several persons, I should say, sought a restraining order under the coercive control law, family law code, and they sought a restraining order and it was denied. And the reason why it was denied was because the judges didn't believe the victim. And victims are not lawyers. They don't know about evidence. They don't know anything like that. And so they go in there and they tell their story. And that story, or what happened, their account, their testimony, is subject to the judge's determination of credibility. Now, we all know judges are not always the best people to judge. And so sometimes these restraining orders or petitions for restraining orders have been denied because the judge didn't believe the victim. And just recently, I did a video. I'm on sort of a regular guest on the Law Offices of Andrew Myers podcast, and we did a show on the ballerina that murdered or that shot her husband, or soon-to-be ex-husband. And the jury did not believe that she was abused. Now, in that case, it was a jury trial because they were seeking manslaughter and murder, and I believe she got convicted of manslaughter. And they didn't believe her. And the reason I think they didn't believe her, and I mentioned it on the podcast, if you want to take a look at it, I'll post a link to that show down below. The reason why they didn't believe her, I think, is because she was showing anger, in my opinion. And Mr. Myers and I had a disagreement. But I believe that she was showing anger, and rightfully so. She should be angry if she was abused. I mean, there's no harm. I mean, that's one of the natural emotions you're going to have. But a lot of women don't express that anger. And, you know, it looked like she was trying to not express anger and trying to express sadness. But the anger came across, to me anyway. And, I don't know if she had tears. I couldn't see any, but my eyes are bad, so I don't know. But, and I didn't watch the whole trial. I only watched clips of her testimony. But that is one of the things that is going to be a hurdle for women or men who are being coercively controlled. And not just women and men, even whatever you want to call yourself. Domestic partners, whatever. The abuse victim, the one that's subjected to coercive control, is going to have a difficult time proving coercive control if they don't understand what it is they need to prove, other than just giving their story. Because if they just give their story or their account of things or their testimony, it's subject to somebody else, like the judge, determining the credibility. So, along with Mica's law, one of the things that would be good is if experts on domestic violence provided some guidance on how to document, how to memorialize, how to capture the coercive control. And it's kind of hard to do because you have somebody up all in your business every 24/7. I mean, that's what coercive control is. They're watching you. They're looking at your stuff on your phone. They've got you. And so how do you prove that? So I'm sure there's domestic violence experts that can talk about ways of proving this coercive control. And I think in Mica's case, after she was away from J.P. Miller, she did give her attorney some information about coercive control, information about what she was subjected to. And that's good, but she was already away from JP. Now, if you're trying to seek a restraining order, based on coercive control, whether it's in California where coercive control is not criminalized, or if it's under the law, Mica's law, if it passes, victims need to know how to present that coercive control evidence. I think I would find it difficult to present something like that, evidence to that effect, if I had somebody who was all up in my business. I couldn't do anything. I can't. Like, it's like I have no private time. Sneaking out in the middle of the night no. So I'm just wondering if there are any experts in domestic violence that could provide some information. For example, I can think of a few things, like having, and this is a tough one, but having someone witness the coercive control, so that person, third party, can write a statement or an affidavit to the court about the coercive control. But then again, that puts a third party in a weird situation. So maybe there's some way that there could be like a written affidavit that is sealed that the abuser does not get to see, at least for the purposes of the restraining order, so that that third party is protected. But I've been thinking about that, and I've been thinking about how hard it is, or how hard it is going to be for a victim to produce evidence of coercive control. Because if the abuser controls all the bank statements, controls everything, then, you know, it's hard. How do you prove that? And furthermore, the criminalization of those behaviors, if they are found, is another hurdle. But first, you got to prove there was coercive control. And without physical abuse, proving coercive control, I think, is a difficult thing. So I think, along with Mica's law, there should be some guidance as to how somebody who finds themselves in an abusive or coercive controlling situation with a domestic partner, how they can gather evidence, how they, maybe if there's some way that a domestic violence abuse expert could give some advice on that, because I think it's going to be difficult. Like in California, some of these people have been denied a restraining order because they can't prove coercive control. And in fact, in this article that I read, that I'll put a link for, there was a bill where judges were going to be required to take training on coercive control and what that means. And the judges didn't want that. They opposed it, and then the bill was withdrawn. So you got to get through to the judge, to be able to show coercive control. And for a layperson, and for me, even for me, I'm a lawyer. I'm not a family lawyer, and I'm not a criminal lawyer, but I'm a civil lawyer. Even for me, if I put myself into that situation where I'm being coercively controlled, I would find it hard to be able to get evidence to bring it to a judge. So that's something that I thought about, and that's something that victims should have some guidance on. And I don't know how, but along with Mica's law, there should be maybe some, and maybe there is, I don't know, but I'm just brainstorming that there should be information on how to gather the evidence of coercive control, because it's subtle. It starts subtle, and before you know it, the victim is in a situation with they can't do anything without permission, they don't have access to anything. Like their credit cards are canceled, they don't have access. So it was just a thought that I had, and not to put any bad light on Mica's law. It's just there has to be something that goes along with it, I think, because it could pass, and it could be a flop because of the judges who have to hear this evidence. And there are people who will also want to abuse that law and try to victimize the victim by using this law and saying that they're being coercively controlled when they are the coercive controller. So they may set it up. And how is a judge, and if a judge is the one that's determining the credibility, if they have no training on coercive control, it's a credibility issue. And if the coercive controller has evidence to back it up, which they would have more resources because they're the ones that are coercively controlling, they could set it up. They could abuse this law. And I mean, I could think of a bunch of scenarios where that could happen. So I think Mica's law is very important, and I want it to work. I want it to pass, and I want it to work. So if people keep in mind that the judge is the one who decides whether to grant the restraining order, and if people keep in mind that judges aren't always good at judging, that maybe there's some tweaks that could be made to the law, or that maybe there's some domestic violence experts that could provide some guidance on how to actually use the law to protect themselves and provide evidence. You know, I'm not a domestic abuse survivor. I've never been in that situation, but I can place myself in that situation. And I know that it would be very difficult for me if I were in that situation to get evidence to show the judge that I'm being coercively controlled. So I don't want to go on and on about this, but you know, the California law, it's under the family code and it doesn't criminalize those behaviors, the coercive control behaviors, but it does allow for those behaviors to be admissible in court, which is not a big, that's nothing new. I mean, if somebody behaves a certain way, that can be admissible in court within a criminal trial. So it doesn't prohibit any of those behaviors from coming in a criminal trial for domestic abuse. It's just, it gives what the law does in California, it gives a greater ground, or it expands domestic violence to include coercive control. So, and part of it is because coercive control frequently leads to violence. And so if a woman can bring, or a man, or whoever is in a domestic relationship can bring a restraining order based on coercive control, then it helps, because even though it's just a piece of paper, an order that says you must stay away, it helps. And a piece of paper isn't going to make someone stay away if they really want to get to you. But that's another issue for another day, how a woman could, or man, or anybody else can protect themselves from an abuser. So those are my thoughts. Let me know what you think. And I may be wrong on what the law is about on Mica's law, but based on what I've seen, one of the things is it wants to criminalize that behavior. And same in California, that's not the case, but in either case, whether it would be under the would-be Mica's law in South Carolina or California, you have to show proof of the coercive control. It could be in the way of testimony, but if you only have testimony, you're subject to the judge's determination of credibility. And that can sometimes be a problem. Anyway, those are my thoughts. Let me know what you think.